Have you ever really stopped to think about what holds a country's legal system together? Well, in Canada, it's not just one single thread. It's more like this incredibly complex tapestry, woven together from different histories, different traditions, and even some really recent court decisions. So let's pull on some of those threads and see what we can unravel about Canadian law.
All right, let's start with what seems like a simple question. Is Canadian law British or French? Easy, right? Well, the answer is kind of both, but also, in a way, neither. And that little puzzle is exactly what makes the real story so much more interesting. You see, at the very heart of Canada's legal system, you've got these two major traditions that came over from Europe, common law and civil law. Getting the difference between these two, well, that's the first big step to understanding Canada's unique legal identity.
So let's break it down. On one side, you have the English common law. Think of it like a living storybook that's constantly being written. Judges make decisions, and those decisions become precedents, part of the story that future judges have to follow. This is the system that's used in almost all of Canada. But then you have Quebec, which follows the French civil law tradition for private matters. This is more like a super detailed instruction manual, a civil code that lays out all the rules for things like contracts and property rights right from the get-go.
So you've got to be asking, how on earth do you end up with two completely different legal frameworks in the same country? Well, it was no accident. It's a direct result of Canada's colonial history and a specific set of rules for how laws get set up in new places. To really get how these systems took root, we need to talk about a concept called the doctrine of reception. This was basically the legal playbook that colonial powers used when they brought their laws to new territories.
So reception is just the official term for how a colony gets its laws from the empire that's colonizing it. And it's not just about influence, it's a formal legal process with its own set of very specific rules. And under English common law, this could go two ways. If a colony was considered settled, the English treated it like a legally blank slate, terra nullius, and their own common law just automatically filled the space. But, and this is a big but, if a colony was conquered like Quebec was, the rule was different. The existing private laws of the people there, in this case French civil law, were allowed to stay. The British only brought in their own public law to handle the government side of things. But here's the massive, fundamental problem with this entire idea. This whole distinction between settled and conquered was based on a fiction. It completely ignored the fact that these lands were anything but empty. The source material says it best. These rules were applied with a total disregard of the presence of Indigenous peoples. And this is just so important to grasp. Long before any European ships arrived, there were already complex, sophisticated Indigenous legal traditions here. And the arrival of European law didn't just wipe them out. Those legal orders survived. And since 1982, they've actually been constitutionally recognized and affirmed. So when you look at Canada's legal tapestry, it doesn't just have two sources. It has at least three. Okay, so let's shift gears and zoom back in on that common law system that governs most of the country. What keeps it from being a total free-for-all, with judges just making things up? The answer is a really powerful idea: the rule of precedent. The fancy Latin term for this is stare decisis, which literally means to stand by things decided. It's the absolute bedrock of the common law. It means that what a court decides today should be followed in similar cases tomorrow. It's what gives the system its predictability. Now, this works in two directions. You have vertical stare decisis, which is the easy one to understand. A lower court has to follow the rulings of a higher court. Everyone has to follow the Supreme Court of Canada. But then there's horizontal stare decisis, and this is where it gets interesting. This is the principle that a court should generally follow its own past decisions.
And why is this so critical? Because it gives the law stability. You need to be able to know what the law is. This whole idea makes sure that similar cases get treated in a similar way, and that's a huge part of what makes a system fair. But right away, you can see the tension, can't you? If we have to stick to past decisions for stability, how does the law ever change? How does it fix its own mistakes? What's a judge supposed to do when they're staring at a past ruling from their very own court that just feels wrong or totally out of date? Well, that exact question was at the core of a huge Supreme Court decision back in 2022. The case is called R.V. Sullivan, and it basically gave us a modern rulebook for when exactly a court is allowed to break with its own past. Now, the key thing here is that the Supreme Court didn't just throw the old rules out the window. Not at all. Instead, it very carefully laid out the very specific, very narrow circumstances when a trial judge can say, you know what? Our previous decision on this just doesn't hold up anymore.
So what they came up with is this clear three-part test. A court can break from its own precedent if, 1, higher courts have made new rulings that have basically pulled the rug out from under the old decision's logic. 2, the original decision was made per incurium, which is a legal way of saying it was made through a serious mistake or oversight. Or 3, the first ruling was rushed, maybe made in an emergency, and just wasn't fully argued out.
What this creates is a really important but limited safety valve. It allows the law to be a living system, one that can actually correct itself and evolve right there at the trial level. But it does this without opening the floodgates and creating total chaos. It's all about that balance between stability and justice.
And all of this leaves us with one final big question to think about. This ruling fine-tunes the engine of legal change, for sure. But in a world that is changing faster than ever before, how do we strike the right balance? As our society evolves, how quickly should the law be allowed to evolve right along with it?